What do you think is the most ridiculous gun law? To me, one of them has got to be the regulation of SBRs or short-barreled rifles under the NFA, and a federal appeals court just upheld that regulation. Welcome back to Sawtooth Tactical. To me, it's absolutely ridiculous. The fact that short-barreled rifles are on the NFA was a mistake. They were trying to ban handguns. Now, of course, they couldn't get away with a full ban, hence the NFA, make it so impossible and so expensive that people couldn't afford to get handguns because a $200 tax stamp in those days was equal to like $6,000 today. Well, luckily the $200 tax stamp has not changed in price, and with inflation, well, it is what it is now. It's still $200. But the fact that SBRs are still regulated under the NFA is totally ridiculous when they only even put them in the National Firearms Act so that people wouldn't have some kind of workaround to make handguns out of rifles. And even though they took handguns out of the NFA, SBRs stayed in it. Well, a man named Jamon Rush just recently challenged that regulation under the NFA when he was caught with an unregistered short-barreled rifle. A 7.5-inch 5.56 Anderson, if I'm not mistaken. So Jamon Rush was caught with this 7.5-inch AR, an unregistered short-barreled rifle, right? Now, the funny thing about that is, depending on the piece of plastic you have on the back of your gun, it could be a pistol. But if you put an actual stock on it, a real stock, it becomes an SBR, a short-barreled rifle. If you pay the government $200 for a tax stamp, then it's totally okay to have a short-barreled rifle, and give them your fingerprints and get put on a government list to where they know everybody that has these NFA items, whether SBRs or suppressors. And yes, I am on that list. I've got SBRs and suppressors. I like NFA items, but they shouldn't be NFA items. That's the thing. The fact that suppressors and SBRs and short-barreled shotguns for that matter, and even machine guns for that matter, none of these things should be any more regulated than any regular firearm, which technically none of them should be regulated at all. Shall not be infringed, right? Well, so this guy's busted with this unregistered SBR, and he challenges it using, of course, Bruin, which is supposed to change everything. Because when it comes to Bruin, courts are supposed to look at the text, history, and tradition of whatever that regulation is at the time that the Second Amendment was written in 1791. Well, in 1791, they did not have any regulation on barrel length. So SBRs shouldn't pass muster as far as being regulated as NFA items when, put up against with the Bruin standard. And so you would think that he would win this. But of course, this federal appeals court, well, they upheld it, which to me is crazy. In this day and age, knowing what we know now with the Bruin precedent, but also just knowing what short-barreled rifles are, and this is the problem. I don't know if in these court cases, if we're just not making our case well enough. Obviously, these judges don't understand firearms, because if they did, they wouldn't regulate short-barreled rifles. They wouldn't uphold a regulation on short-barreled rifles, because it's absolutely ridiculous. Your gun is totally fine if you put a less comfortable piece of plastic on the back, and you are allowed to shoulder it. But if you put a more comfortable piece of plastic, you have to spend $200, or else it's literally a felony with a $250,000 fine and a possible 10-year prison sentence. So this video is brought to you by Aura. Aura has been the biggest sponsor of the channel for the last year, and I really appreciate any of you guys that have clicked the first link in the description and signed up for Aura. It's only $12 a month, but if you use my link, you get to try it out absolutely free for 2 weeks, 14 days, to see if it is worth it to you or not. And what do they do for you? They provide you all of your online security. So while getting an SBR or a suppressor, yes, it puts you on one list with the government. Well, Aura goes in onto the internet and onto the dark web and they find wherever your name and information is on any other lists that are being used by data brokers to sell your information to scammers and spammers and other bad actors, and they submit opt-out requests on your behalf, taking you off of any of those lists so that your information isn't out there anymore. It makes you private again. And in this day and age of us all being on the internet, you're watching a YouTube video right now, your information has been leaked. Whether you do online baking, whether you buy stuff online, your information does get leaked. Anytime you put your email address in something, a lot of the times those companies, they're selling your email address. So if you want to get all your stuff off the internet, it's very easy to do. Try out Aura for 2 weeks, 14 days, absolutely free using my link or by clicking this QR code. Now the link, of course, is aura.com/sawtooth-tactical. 2 weeks absolutely free, and then it's only $12 a month after that. And you get a lot more than just data broker removal. They cover all of your online security. So all of the stuff that they do, if you added it up, would be much more expensive than $12 a month. But Aura just packages it all together, very cheap. But again, 2 weeks free at aura.com/sawtooth-tactical. So the federal appeals court that upheld regulation under the NFA of short-barreled rifles, in this case of Jamon Rush, what they used was Miller. So in Miller, they upheld the regulation on short-barreled shotguns. So this federal appeals court said that, that Miller was still good law. But Miller was before Bruin. And so technically it shouldn't be good law anymore because there was no regulation on short-barreled shotguns, short-barreled rifles, suppressors, any of this stuff at the time the Second Amendment was ratified, put onto the Constitution. And so there's no reason to have this regulation at all anymore. And what should happen is anytime that one of these things is challenged in a federal court, we should win. In my opinion, and of course you guys know this is my opinion because of what I do here, the judge got this wrong. I think that's blatantly obvious to anyone that understands firearms, but also to people that understand law and law that sets precedent, because Bruin is the law now. And I don't feel like this federal court, used Bruin correctly, because if they did, I think that Jamon Rush would have won his case, at least as far as on Second Amendment grounds. I don't know much more of the details about his case, but technically, there should be no such thing as an unregistered short-barreled rifle. You should be able to use whatever barrel length you want. The only reason that so many people have 16-inch barrels on their ARs is because that is the arbitrary barrel length that they came up with that makes it a rifle. And even that was a weird compromise. Originally, that barrel length was 18 inches. And then the U.S. government was selling a bunch of firearms to the general public that happened to have shorter than 18-inch barrels. And so they had to change that arbitrary barrel length to 16 inches. And the whole thing is absolutely arbitrary. When you look at some of the pistol braces out there these days, the only difference between most pistol braces and a stock is the pistol brace is just not as comfortable. And it's usually kind of a little bit jankier. And so it's just not really very logical to me that in order to use a good stock, you got to spend $200. Like, this is an SBR, this is an SBR, this and this. I've got 4 SBRs. And I got those tax stamps for mine because, especially if I'm going to be putting my stuff out there on YouTube, I have to make sure it is totally legal. But it's kind of ridiculous because, before I got the tax stamps, I had pistol braces on them, SBA 3 braces. And I was able to use the guns exactly the same way. They just didn't look as good and the brace wasn't quite as comfortable. And so you're totally legal if your brace, if your piece of plastic on the back of your gun is just a little jankier and less comfortable, but you put something better on the back of it, that makes your gun more safe because you obviously can be more accurate with a stock than without one. And you want your rounds to impact where they're supposed to. You're responsible for every round that comes out of your gun. You don't want stray shots. That's a dangerous thing. And it seems like that's what the ATF and these courts want, though. So let me know what you think about this. Do you think that it makes any sense that if you pay $200, total having a stock on a short-barreled rifle is totally safe? But if you don't pay $200, having a brace on it is totally safe. But if you don't pay $200 and you have a stock on it, well, go straight to jail. Do not pass go. Do not collect $200. Kind of funny. Anyway, I want to know what you guys think about this, because since Bruin, I would have expected that these kinds of challenges would win. And I think that they should. But this one did not, which is kind of a big setback as far as, I guess I need to manage my expectations. But let me know what you guys think down in the comments. I try to read every comment. I try to reply to as many of them as I can. And I appreciate each and every one of you. From Sawtooth Tactical, stay strapped or get clapped.